Do we do an all rise Zoom?
They didn't last time.
Okay.
That's Mark's on that side. I mean, Vannetta.
Vannetta.
It's not on yet. Yeah, I'll do it, because when you guys aren't talking, I'm gonna mute it, so there's not enough.
That's fine, thank you. Thank you.
Okay, I'll fix it.
I'll ask your county to mute.
Can you hear us, Judge?
We can, thank you very much. I will call the cases. Rita Anderson et al. Plaintiff versus Mineral County Attorney. This is DB 22-53. And then Rita Anderson et al. Plaintiff versus Mineral County Sheriff. This is DB 22-54. We are here for a status conference on the progress made pursuant to the court's writ of mandamus in both actions. I have reviewed the update to the court submitted by Mineral County, as well as the update received from petitioners, and then the respondents' corrections to petitioners' update of January 27, 2023. I received those in both cases and reviewed those. I will first turn to petitioners to provide updates orally if they wish, or supplemental to what has previously been provided.
All right, thank you, Your Honor. So I did just receive a response to our update that was titled corrections, and I have not had time to review that. But as the court can see, we are still waiting to review the personnel files for which there was an order, protective order signed by this court. The applications for employment are still outstanding. There are some issues, I think, based on this correction file that we either need to go through today with respect to the disclosures made to previous defendants, or I need to have a phone call with maybe Ms. Jackson about, because what happened was right before the 12-2 hearing, we got quite a large discovery done, and I have tried to go through it, and I might be missing something, or maybe I'm not communicating what we're missing correctly. So then that gets us through, Your Honor, the update through number 3. Number 4 was policies and procedures. They are outstanding. I know that Mr. Herman filed what seemed to me to be an application to be a deputy. I think those pages were out of order, and I thought maybe I would find the policy and procedure in there, but I didn't. And so I don't know if I'm missing something, but that was not there. We're still waiting on a lot of emails, Your Honor. Number 5, specifically though, if we look down to number 15, I think there's a misunderstanding between the parties. What we're asking for is the county or the state would have retained emails from their employees. And it's my understanding that Ms. Jackson has stated before that she does have the emails that Ms. Donahue had sent from her work computer. The last time we met, Mr. Condon was going to speak to IT. That was at our 11/16 meeting to see if he could procure those emails from us. And then the letter, we did receive a letter from him saying he would need to subpoena Ms. Donahue's personal phone. At this point, I don't think that that's what we're asking for. We're asking for any correspondence that were through the county server. And I don't know if it is their position that they can't access those, but that's not been my understanding based on conversations with them. So sorry to skip around. With number 7, any information or documentation regarding Deputy Councilman being placed on leave, I would need to confirm with them that he was not placed on leave and therefore this does not exist. We're still waiting on number 8, any new policies. I was hoping to see that again with the application, but I believe they've been done, so we should have those. Organizational charts. We're trying to understand the workflow and structure. So these, and Your Honor should know these are things that we all agreed to at our meeting. So it might be that if I miswrote them or something, certainly Mr. Conklin could speak up, but we had a meeting, it was recorded, and I went through and made sure that we were in agreement about these disclosures. 11 still outstanding. There was a letter sent to us that Mr. Herman will be forwarding and copying the persons placed on administrative leave. Again, he's trying to do all this, we just don't have it yet. Information related to the termination of Deputy Nobles and Deputy Byzantine is outstanding. Specifically, Your Honor, my concern with respect to that email regarding Ms. Donahue, there's one email that was sent on December 10th. We have a cut and pasted version of that. It is cut and pasted by Deputy Byzantine. It's an email wherein Ms. Donahue emailed all of the witnesses at a specific hearing after Judge Deshaw issued an order saying that Deputy Byzantine made false representations. The email is from Ms. Donahue directing the witnesses to essentially write affidavits about how they disagree with the judge. There's a subsequent email from Ms. Donahue to Mr. Jasper in a different case where she says that she hadn't read that order correctly and that essentially that's why she hadn't been sending it out. And so we're just interested to see kind of what kind of documentation was done with respect to that order and what orders were given. At that point, it's my understanding that she was in fact aware of what the order said based on that December 10th email and was not disclosing it purposely and knowingly. So they should be able to get that to us. Again, 17 kind of deals with 15 and 16, it looks like that's in the works, which is good. Mr. Jasper was talking about the depositions. The statute requires on number 19 that the sheriff come up with a specific mental health tool to be used by the sheriff's office. And Mr. Conklin has said he would give that to us. I'm afraid because it wasn't explicitly listed in our letter, and we just talked about it orally, that it just might have fallen off his radar. So we're still waiting on that. And then numbers 20 through 27, I believe, and I'm not certain, but it seems to me that these are efforts made on behalf of the sheriff's office to do some kind of background checks and follow up on the individuals who are in their employment. And so therefore these subpoenas were sent out. These are the ones that have been filed with the court. I assume they're the same ones that were issued on December 5th, and there aren't any more, but I don't think they were actually filed with the court until later in December. So we just want to double check to make sure that we have everything. I got this from the actual court file. From one of those, we have received information number 20 from Lake County. But that's essentially where we are. I think they're making good progress in my understanding of changing their policies. A couple of the policies that we would be specifically interested in would be, obviously their hiring policies, but policies around when someone in the sheriff's department reports a potential Brady or Giglio issue and how that flows through their department to the county attorney's office. And then additionally, one of the problems that we've seen is when someone reports an offense alleged to have been committed by someone within the county, how that offense will be investigated. And those are, again, things that we discussed at our November 16th meeting, and I do believe that the county's working on those. So I think that's all I have. Oh, I have one more thing. I'm sorry. The other thing, Your Honor, Mr. Condon had sent us the protective order to review before he filed it, and it's since been issued, but the only issue that I had with it, and I had sent a letter to him expressing this, was that it only allows for one of our secretaries to view this information. We're a small firm, but we do have 3 staff, and they all share duties, Your Honor. They share filing duties, they share saving duties, and 2 of them specifically are working on this case list, and I have separate paralegals. So I had asked Mr. Condon to make that 3 to allow for, just so they're not going to be looking at it, but they will be touching it. And so I would just ask that the court amend that to allow for 3 of our staff to have access to this documentation, and I'm happy to submit an amended order to the court. I'm not sure what Mr. Condon's position on that is, though.
Your Honor, I thought,
Judge, with regards to the depositions, we were able to accomplish one deposition of the undersheriff, Mr. Cashman, in this, and it provided a lot of information about policies that we were unaware of, and are able now to request, and were being kept in the sheriff's office. We also requested Mike Toss deposition, but he was ill at the time, so that got rescheduled. However, based on the review of the recent county commissioners meeting, it has been brought to our attention that former Sheriff Todd has essentially either deleted, destroyed, or made it impossible for the county to access his emails, and it's imperative that we get a deposition of Sheriff Todd to figure out why he would do such a thing given the situation that's pending and the duty to preserve evidence. Likewise, one of the issues has been dealing with is the personnel files and how those were being handled, and the hiring of these deputies. And so the former HR individual is a Dawn Terrell. We asked for her deposition as well to discuss how the hiring process was being taken place and what changes obviously are going forward. Those 2 really are an important one. We've also requested current Sheriff Ryan Funk's deposition, and whether it needs to be a deposition or could be an interview is up to the county, in the sense that to my reasoning for him is, one, to talk about prior hiring practices and the issues surrounding what now former Sheriff Todd did in the destruction of evidence, but also it's just the any progress that he's made or changes that he's made that will help us in seeing that the mandamus order is being complied with. I requested these dates, and I have not heard back from Mineral County on them in the response letter that I received from them. So those are 3 that need to be done. I think to get a real handle on ways to make sure that everything comes into essentially compliance.
anything further you wish to add?
Not at this point.
I want to give him and Ms. Jackson an opportunity.
Just several notes, Your Honor. I had believed that we had changed the number of persons to look at the files to 3 instead of 1. And if that clerical adjustment I asked didn't go through to the filing that went to yourself, that's an error on our end, but I do believe we changed it to 3 from 1. So I thought that was taken care of, but if it's not, if it didn't get through to yourself that way, if we can change that to 3, that is not a problem, because I understood Jordan's comment about that they had 3 people that were looking at files and they would be found by the same order. That was fine. So that was okay. In respect to the deposition schedule, Ms. Carroll's out for probably another 3 to 4 weeks with a medical condition. And when she's back, we'll schedule that. We have not heard back from Mr. Toth on a schedule for him. We still have about 3 hours or 4 hours to do with Mr. Cashman, I'm told. And then Mr. Funk's deposition will schedule as soon as we have a time that works for everyone involved and can do that. So the deposition schedule is not an issue. As the subpoenas have come back in information, one of those is on your desk now being reviewed regarding one person. Another one came in now, and then part of that file of Mr. Cashman that came back from the Arizona connections, I went ahead and forwarded those documents to Lance's office. So they can see those, that was minimal pages, it's like 12 pages or something, but it was minimal. But as they're coming, we're forwarding them either to yourself or the ones that seem to be generically routine. I just tried to send to Lance as they come. I think I got another one this week as well regarding the deputy that was hired about 3 months ago. So those go forward to yourself as well and on to Mr. Jasper. We have not got the code to look at the file that's on your desk, because when that was sent back from Lake County, they sent us a thumb drive, but they sent you the code. So I think to comply with the order, when you have reviewed the file, we will need to get the code so we can review that file as well. And that would solve those questions. I think at that point, in the deposition, or the discovery question of emails from Ellen, I was looking for the ones, because in previous hearings in December, Lance indicated that some of the emails or texts that came from Ellen were on her own phone. So I was working on how to get that information as well, because I thought there were some of those out there. But the ones IT said we didn't get from the county's computer system, I don't think that's a complete record. So I was trying to get a complete record to forward that on at the same time. But it's adequate for now to send the stuff IT can get us off just the county's computer. We can forward those things regarding Ellen or conversations immediately. There were only 2 officers placed on administrative leave. That was Deputy Nobles and that was Deputy Allard. Just those 2. No other persons that were asked about were ever on administrative leave, and there were no others from the other departments in law enforcement placed that way. So we verified that, and I put that in the letter response I sent the other day. So if that kind of gives you an idea of where those things are, the other disclosures are an updated list for you that were sent and that they are. So I'm not sure where we're at with that, but that's the information that we have so far. And it has been a landmark amount of information to gather up. It is difficult to get people to send information back because they're having to go through files of errors that are 4, 6, 8 years old to get information like Mr. Cashman, et cetera. But they're doing it, and that's just taking some time.
I don't know that I've actually received it. I know that the clerk is placing in the mail the letter and the thumb drive. I think it may still be in the mail process right now. Sometimes mail comes slowly when addressed directly to the court. So I don't know that I've actually seen the letter, but I know that that is in process of being sent. And on receipt, I will review that information from Lake County that was responsive to the subpoena and identify what materials are appropriate for providing to counsel from both sides. Okay. What about the issue of new policies, Mr. Condon?
There were 2 parts to that. These documents that I sent to stack up were the things that the sheriff's office worked on for their internal hiring questions, including a record. So that became part of the policy to follow. And the policy manual itself had 3 sentences added to that, and that's a separate page from the employment policy manual, but I can forward that as well. And we also had the representations that we made to the court, which we started following in December, regarding commissioners, county attorney's office, et cetera, interviewing and approving, hiring for persons that were deputies and their background checks. So I have those 2 things that I should probably send on. The biggest one is the corrections that were put in the policy manual itself, not just the corrections and the additions that were put in the sheriff's internal hiring questionnaire and hiring questions and background for deputies and detention people. And that's the full set that I sent to Lance and Jordan this last, I think the week before last or last week, I can't remember, but they have that set, which is one of the biggest changes.
Your Honor, could I interject?
Go ahead.
I just want to make sure we're talking about the same things because I'm uncertain. I did get what was filed as an update to the court with what looked like an application for deputies. And if that's what Mr. Conlon is talking about, we did receive that. However, we are interested in the actual policy manual, previous and current for HR for hiring. And so it wasn't clear from the order that if that was included, but I didn't see it. So I just want to make sure that I'm not missing something.
I will add that. I will add that page and send the same as I did not in the previous file, but they go hand in hand. One is the bigger manual, the other is the policies that the sheriff has some specific ones that come from the national guidelines, et cetera. And we updated both because we said we would do that, and we have. But I will give that on the page to Jordan and Lance if they have not gotten it in the earlier stack that I sent.
Well, and I agree with Ms. Kilby that in reviewing the update, I saw that as an application. I didn't see necessarily policy changes, whether those are modifications or new policies.
Okay, the policy manual has some of the single line changes, but the application portion had the other changes in it for what you did for background checks, NCIC, et cetera. So both IBARs changed, and we did that for the reason. But I will get the annotation, I will attach it as well to our update.
Okay.
Your Honor, I just don't believe I have the whole policy, so that's what I would like.
So maybe I think it's best to start with former policy manual and current policy manual.
Sure.
And if those can be provided in a assessing format, you can also compare them.
Thank you, Judge.
Would you also like a copy of the former sheriff's application policies before Mr. Castro and Mr. Funkley wrote those as well, that we had 6 months, a year ago? Because that's different than the policy manual itself, but I should probably send that too. So you have the former and the
Yes, please.
conversation. Okay, we'll do that.
Yes.
So it seems to the court that there are still items outstanding, and but I don't hear any objection necessarily to providing them. I think some of it has been some misunderstanding about what exactly is needed. I also believe that some is the fact that there's limited person power to accomplish these, and I think that the county is acting in good faith and proceeding. I would like to see continued progress by scheduling depositions, getting the policies exchanged, obtaining whatever emails can be obtained prior to going to private sources like a subpoena to the former county attorney or anyone else. I want to make certain that we first exhaust and review the county's materials before having to go and start drawing in private individuals, because that's going to require substantial in-camera inspection of those materials to protect their privacy. The amount of information contained on private devices is immense, and I don't want to burden the court with a review of all of that material. So I think it would also be helpful, Mr. Condon, to have an IT specialist or the IT individual provide a report about what Mineral County sees on its end as far as the TOF emails and materials. Usually there's some ability to at least know from actions and the computer log what activities were taken. I think that is important for transparency purposes to make certain both the petitioner and petitioner's counsel in this case, as well as the court, have an understanding of what occurred, and frankly, it would inform any deposition of former Sheriff Toth as well, because then knowing what actions were actually taken, they can ask specific questions.
In that regard, Your Honor, I think specifically Mr. Funk showed me there were 3 devices that were in question. There was a laptop computer, there's the main computer that IT can recover from our friend. There was another device, I don't know what it's called, it's larger than a cell phone, smaller than a laptop. And kind of like a notepad, there was a computer device as well, and that one seemed to also have some issues. So I think we're going to take that one as well, see if we can get the password to that from Mr. Toth, and then see what we can gather from that, or see if IT can recover that information. That's a different device that Mr. Funk found out in the office when he cleaned the office out. So we have that one to recover as well. If there's anything.
I think it would just be helpful to have, none of us are IT folks, and it would be helpful to have some report about what the IT person sees, without impugning former Sheriff Toth or anything. It can be just simply an objective, we're missing emails from this date, or they appear to be corrupt. I don't know what occurred, but it can be a fairly simple report, recognizing that forensics are always a bit complicated anyway, but I think that report would be helpful in understanding what occurred, because some of this can occur as a matter of human error. In fact, most things happen because of human error. So I just want to get more clarity on that particular issue.
We will get that from our IT people. We'll also provide a copy to the court, besides Lance and Jordan. We'll also provide a copy to yourself, Ron.
I'd appreciate that. And then what about this issue of the mental health tool by the Sheriff's Office?
The statute, go ahead.
I think that was
On that, Your Honor, the Sheriff's Office actually contacted our office and asked essentially the way in which one would do a proper mental health evaluation or a fitness for duty evaluation to be conducted, and asked the sheriff that in that situation to use Dr. Stratford, who is used by Missoula County, who uses a formulated testing platform to determine that. And so, and then he was looking at hiring a potential deputy and asked for advice. And so that recruit or applicant provided us with a release, and I just did as they asked to look at it looked to me as if this Micah Howard would be qualified and he's provided the report combined with my access to the post on it. And so I wrote them a letter, and I thank them for trying to comply with the spirit of the mandamus on it to see that we're getting qualified individuals. And so I really think that that's a big step for the sheriff's office to have taken that step. And so I encourage them to continue to incorporate someone like Dr. Stratford that has such a high level of education and actually does the testing that would normally be required by other jurisdictions, including Missoula, Butte, Bozeman, Anaconda as well. I've worked with, and they use Dr. Stratford as well with the formalized testing. So anyways, I was impressed that they offered and asked us to do that, and hopefully it allows them to make contacts and continue to implement that. So it was a good thing to see, at least from my eyes.
Two notes, Your Honor, this is an issue. Mr. Allard interviewed for a job, and based on the conversation with the commissioner, the interview, and the county attorney staff, the sheriff was informed that there were some gravy issues for Mr. Allard, and we would not hire him at this point because of those issues. We'll look at that maybe August, September, or something later if there was a question. However, it's interesting to me that now we find out the counsel for the opposing party is advising my client, the sheriff, which is the office, not just the sheriff. As you indicated, it's the office it's against, on what to do, how to do with that question, Mr. Allard. And the directive from the commissioners and the county attorney staff, per the process we approved through you, that we represented to the court, and the policy manual, has now been flown in the face of by the sheriff, who's my client, or the office is my client, as well as against the representation we made by the court. So we need to not be having counsel for the opponent, counseling the clients from the county in Mako who are defending the proceeding and trying to comply. And this has been an ethics issue in my world, because I would talk to other people's clients in a lawsuit, I never would, but that seems to be what's going on now. And the question started with what test was required. Well, the state law requires a medical person to ask the questions, but I agree, a higher standard may be more appropriate, but the way that we got there was inappropriate, and what was asked was inappropriate, because we had directed them that Mr. Allen could not be hired because of two issues that we did not wish to have to confront at this point in time. In a settlement of the lawsuit, he was adding some other things that were not to be disclosed, but also there was a release for third-party information, and I have a 2-inch file on those questions that we thought was better to not go down at this point. So I think it would be appropriate if Mr. Jasper did not do those things with the sheriff's office anymore, if the sheriff did not do that anymore as well, then Mr. Allen should sit quietly in the wings and not be hired until we resolve these questions, because there's some serious issues from the file question and where that went and what was done.
Response?
I'm a bit stunned that someone would call the opposing counsel, and opposing counsel would also offer the advice, offer the rest in an adversarial proceeding, which is what this has been thus far. And that does not seem to be an appropriate course for this thing to have gone in my book.
Well, let me start by two things. One, it was a request in the spirit of the mandamus, and I took it as being an individual trying to comply with the court's order and doing it in a manner such that it would be done right. And my letter to them was simply that I did not find anything that would prevent Micah Allard from being hired. Now, his decision to hire him is something else. The fact that you're thinking that I've done something other than try to help, if you consider this adversarial, at this point, I think that that's not the purpose of it, Wally, is what we've been doing here is trying to facilitate compliance with it. But if you don't want us to assist with it, that's great. I'll file and move forward just with violence, but, you know, to try to help Mineral County is why I got involved in this. It is not a situation of, trying to tear Mineral County down. If I would have wanted to do that, I would have filed lawsuits. And so, I look at us as an instrument, and what the court has provided us was the ability to act and be able to see that both the law and the hiring is improved in Mineral County. And doing so is part of my obligation. So, you know, I don't know what your sheriff has done, if he's hired out, that's something between you and the sheriff, not between me. All I did is gave my opinion that he was qualified to be a deputy based on all of the background information I was able to look at, which was everything.
Actually, I would disagree, Lance. You didn't see everything because I have the rest of it, the third parties that Michael released it to, number one. Number two, I don't have your letter. Number three, I appreciate the help that is done in that spirit, but at the same time, it kind of flies in the face of the sense of fair play in my world for how it is, and I don't have your letter. So it would seem to me the best thing for us to do is to try to minimize that issue in the future. If the sheriff calls, it would be best to call us and say, we have this inquiry, why don't you talk to the sheriff and let's do that. That would be fine with me, but it just seems very behind the package in my world. The sheriff did it without telling us, so my first question is, can I trust him? Two, you did it, you didn't tell me or Dad either. So the second question becomes, who can I trust in this proceeding? And that seems very unpleasant for me. And I don't wish to have a Brady sheriff, because he won't talk to the people who are trying to represent, quote, the office, which he has, not just the person. And that is a very unpleasant circumstance to find ourselves in. So I would say perhaps we're best off to figure out a better plan and talk to the court about it later, but let it go at this point in time, but just try to cease that until we figure out a better way to deal with this, because I don't need to pound anybody over it right now, I don't think.
Well, I want to give the quote, and that is, for Mr. Jasper, all communications with county employees, at least regarding this particular matter, ought to go through the county attorney's office as their formal representative. I would say that I think there has been cooperation and collaboration in this, and I appreciate that the parties are working together to better the process and to have a full and fair disclosure of all the information. I do believe that this is still nominally an adversarial process, and we can tone down the adversary part of it, but nevertheless, the process as we work in our legal system is one that is an adversarial one. I would have any inquiries that you receive directly are also forwarded to Mr. Condon. We would provide a copy of that letter that you sent to Mr. Condon as well, so that he has information. And of course, I think it's incumbent upon the county to advise its own employees and office holders that, again, matters related to this particular, these two suits should be done with the advice and understanding and knowledge of the Missoula County Attorney's Office. So at this point, the court's not going to take any particular action. I've heard any requests for the court to take any action, and I'm going to continue to encourage you to work together to resolve some of the discovery issues that are still outstanding, and get those settled as quickly as possible, and keep moving forward on both the disclosure of information, the creation of appropriate policies that would address these issues, and to again, follow the terms of the Writ of Mandamus so that court's order can be realized.
If I may, Your Honor, a question. I do not wish to pour water on Ellen Guy's parade or something, but if I prepare a gentle subpoena regarding her personal text and phone messages and forward a subpoena of that type to yourself to sign, would that be okay? Because I'd like to get that information, because I think it may help all of us. And 3 times on Jordan's updated list, I see a request for information from Ellen. And I think the sooner we get that, the sooner it will solve a lot of seeing the whole picture. If you know what I mean, Your Honor, in the spirit of cooperating and trying to see the whole picture. So if
So, Your Honor, that may be necessary at some point, but right now, I think it makes sense, as the court has stated, to start with what we can get from the county before we put all of that on the court to review. If for some reason, I haven't seen what Mr. Cohen is talking about, I've seen reference to it. So, I think if we can review what's been saved on the county server first, then we may be able to avoid that, but I also don't have any reason not to defer to Mr. Congress' judgment on that at the time. I just don't have any information.
So, I understand your request, Mr. Congdon. I understand your, your desire, Ms. Gilby. It seems to me that if Ms. Donahue's text messages and emails that may have come from her personal account may be at some point important, the court would endorse an ability for there to be a forensic copy made of her personal device, depending on what age that device is. I will tell you that LNG Security can perform that, and I think it's about $150 to $200 to have that forensic copy made, and that copy then could remain with LMG. And if there's another forensics outfit, I'm happy to inquire about or consider that. But that would then say it would not be subject to any review by anyone but stay in the possession, because text messages are routinely overwritten. Emails are archived and deleted and lost. And so if it is keen for the parties to perhaps have that information, we have to go beyond merely a document preservation request, and Ms. Donahue could actually probably do a forensic copy of that particular device in order to preserve that information.
Just a quick question. Wally, have you just asked Ellen if she would provide the text messages?
I left a message for her, and I'm going to probably call Monday and do the same, because I think I can catch her in the Anaconda office. Also, I had the idea when Judge Vannetta was speaking that perhaps the other device that Ryan Funk found, is LNG or is it LNG, the security company?
It stands for Lake Missoula Group, L.M. Mary.
Thank you. So if LMG could copy that as well, or get into that and do that, that would be helpful to get as well. So I will not only limit us to finding Ellen stuff, but I'll get you the IT report immediately. But I will also see if the other top information we're looking for, if LMG could perhaps salvage that and get some of that story recovered too. Because we should have all those, I believe, for this process.
And then, Wally, my understanding is from the commissioners' meeting is that efforts to get the passwords from former Sheriff Todd, he will not do that on it. And is that correct?
I did not hear that from him, and neither did Don Carroll. I don't know that Ryan asked him for this or not, but he did not indicate to me he would disclose the information, and he did not indicate that to Don Carroll. And I can call her at home and get his cell number and try to sort that out today or tomorrow on Saturday if I can catch him in Billings where he is.
well, I think, just in thinking this out loud is that, we've given, Sheriff Hoff the opportunity 2 times actually to do depositions on it. I think what we now should do is, you and I pick a time that works for us, and we set the time for the deposition, and then we just have a word to compel to be there.
I think that is probably a good idea for how to get here to do it. Or to the Zula lands, if you're comfortable doing it there, it's fine with me.
Yeah, we can do it in our office.
Okay. That would be good.
Okay. One of the things, Your Honor, and I think that we're kind of sketching around a little bit on this, but I think when we get to the head of this snake, in a sense, it's going to, a lot of it's going to lie with Sheriff Todd. And if we know that for sure, then essentially we can lock its head off and hopefully allow the new sheriff's department not to have that problem in it, which will then make all of life easier in Mineral County on it. And so to me, that's kind of the head of the snake that I think that we need to at least look through, as if this was a part of the main problem, that we isolate it and keep it from, in fact, what's currently going on. We may well be at least halfway done.
Although I'm not sure I'm keen on the snake analogy you're using, Mr. Jasper, or lopping off heads, as the case may be, I understand what you're saying, and the court stands prepared to issue any subpoenas that may be necessary for the deposition.
Thank you, Your Honor.
Thank you. When would be an appropriate date for our next status conference, where the court would expect that some substantial progress has been made on, again, the outstanding discovery that has been requested and agreed to, which includes policies and personnel files and applications, as well as additional requested information.
We'll defer to Walter to see what he thinks is going to take him for time.
I think the first week of March, the water might be fine. If the water compact filings are due next week for Mr. Jasper and myself by the 9th. So we're finishing those for people, but there's plenty of time around that. And in the meantime, to finish the discovery, I hope more subpoena information comes back. And if you would let me know Monday, if the thumb drive has not come to you in the mail, Your Honor, I will get hold of Lake County and try to get another one. But we did send that one to you, I know. But if it's not,
I do know the clerk's office. I will do another search through our materials elsewhere in the mail.
the first week in March is fine with us, Your Honor, if that works for Lance and George and the court.
Unfortunately, it does not for me. The court has a number of trials in late February, and will be out of office beginning March 3rd.
He'll be here the 29th.
I think the soonest, actually what we could do is tie this to March 29th, and the court will be out, I will be substituting for Judge Larson on March 29th. Is that too long?
That is ideal with us, Your Honor, and we will try to have all the things that were questions in before then, or the vast vote for sure, provided you got the subpoenaed information back from other employers out there.
So Jordan's out that day, so fortunately, if it be possible, could we do like this Friday afternoon, maybe the 24th?
I could potentially another 2:30 to 3:30
That's fine with me.
on Friday the 24th.
That is fine with us, Your Honor.
We will set our next status conference then from 2:30 to 3:30. You note that I have at 3, so brevity, the order of the day, but Friday, February 24th. By the way, counsel, the court does endorse the manner in which you have set things up in the table. I appreciate that, and would encourage you to continue to use that table to reflect progress or outstanding matters, as the case may be. Anything else we need to address?
March 24th, correct?
Actually, I said February 24th. Okay.
I apologize. That was fine.
February 24th, which is a little less than a month. Okay.
Thank you, Your Honor.
Okay, thank you to Mineral County, thank you, folks in Missoula County, that we are adjourned for this matter, this is